I'm not quite sure how to describe this video, whether it's a add-on video or a tag-on or a what, but the purpose of it is to clarify something from a previous video that I've already covered. We were looking at municipal domestic courts as a method of resolving international disputes. And I remembered from last term that some students had difficulty distinguishing between civil matters and criminal matters. Civil, nothing to do with civil law jurisdictions. Civil means private law matters, and criminal means public law matters. Pardon me. And so what I want to do is go back to slide number 7, where I talk about public law and private law in Canada. Public law is the government on one side and the government on the other, like a constitutional dispute, or the government on one side and a person on the other, Regina versus Dudley and Stevens, a criminal law matter. And then we have private law, and that would be the Holden versus Graham concept. Well, on the very next slide, we talk about public international law and private international law. And if we then jump to screen 9, you'll notice that in the list of public international law and in the list of private international law, you don't find criminal law. Okay? And that's because criminal law is basically considered a domestic legal matter, a municipal legal matter. It may have an international flavor if, for example, an international criminal is passing through Canada and we grab that person and we put him on trial under the protective principle. Or we grab a terrorist and we try him under the universality principle. But other than that, the nationality principle, the territoriality principle, these are domestic, private law matters as opposed to private international law matters. Okay, so let's look a little closer at the distinction between a civil law matter, which means a private law matter, and a criminal law matter. And I've got a slide which from my previous class, Law 1, that looks like this. And I'm going to post it on Moodle, or eLearn rather, just to you can have it handy and then I can explain it to you. The diagram shows on the one side a criminal law matter. So this is assault, battery, theft, murder, fraud, and it's the Crown versus the accused. The Crown is the government's lawyer, and then the accused will have a defense lawyer. It's not Crown versus defendant. That's American, and we see that on TV all the time, and as a consequence, we get a little confused. The trial is in criminal court, okay, so that'll either be the provincial criminal court or it'll be the BC Supreme Court criminal division. And the level of proof in order to get a conviction is beyond a reasonable doubt. No, it just says beyond a reasonable doubt. It doesn't say absolutely no doubt. So, but it's still a very high level of proof. And it's on the Crown to prove that. The person can select the accused. See, I almost got caught there. The accused can choose judge alone or judge and jury, and it would depend upon whether there was some advantage to the accused to have a jury that might be sympathetic, or whether it's a strictly legal concept that a jury wouldn't understand, but a judge alone could distinguish. And then there's either a verdict of guilty or not guilty. Okay, if it's not guilty, then the accused goes free. If the accused is found guilty, then he goes to, or she goes to, a sentencing hearing, and they decide what sort of sentence the person should receive. That's on the civil, or the criminal law side. On the civil law side, we have a thing like a breach of contract or a tortious matter or an estate matter or a property law dispute. Okay, and you can see that in the private international law. So now, on the civil law side, you can have something that is purely a domestic dispute, or it could have an international dispute. Okay, because torts and contracts and transportation and financing and intellectual property are listed under the private international law on slide 9. So what do we got? Well, if it's a small claims court matter, then it's the claimant versus the defendant. If it's a BC Supreme Court matter, and generally on an international case it will be the plaintiff versus the defendant. Most cases are settled because many are filed that don't go to court. But those that do go to court, the decision is based on a balance of probabilities. Okay, which means the plaintiff has to prove his case sort of 50.01%. That's being a little over dramatic, but basically you have to get the scale of justice to tip in favor of the plaintiff, and then the defendant is guilty. No, the defendant is not guilty. There is no guilt in a civil case or a private law case. There is only liability to pay damages or some other remedy. Now, in a criminal trial, it is the accused that gets to choose whether there's a jury or not. In a civil law matter, it is the plaintiff that gets to choose. You can choose judge alone or judge and jury. Criminal matter, 12 of your peers. Civil matter, 8 of your peers. Okay, and you think, oh wait, well you could have a stalemate, 4 and 4. Yeah, that's the whole point. Okay, you have to have the scale tip, so you'd have to have 5 of the 8 think that the defendant is liable. Okay, there is a judgment. And the judgment will involve either the case is dismissed, which means the defendant won, or the plaintiff or claimant won, and then there would be an award of damages or an injunction or some other remedy. So that's the distinction, and I think that's important to keep in the back of our minds when you're looking at municipal domestic courts for the settlement of disputes, because the method of taking jurisdiction in a public international law matter is substantially different for a criminal matter than it is for a civil law matter. All right, that's all I wanted to say in that one little video, and as I mentioned, it's just a tag on, so you'll know why you see that pop up.